Institute of Constitutional and Parliamentary, New Delhi. He has guided doctoral research works in law. Dr. Jayaprakash Yadav has done on the topic of state obligation to enforce directives under Part 4 of the Indian Constitution, the goal or reality. He has got published 6 books published and successfully organized national faculty development programs, national seminars and conferences, and also national moot court competitions. So I welcome you all for giving us time to give the lecture. Welcome you, sir.
Thank you, Jaya. Thank you very much. Good morning to one and all present on this virtual platform. First of all, I would like to thank and feel privileged that my alma mater invite me to share my views on personal liberty and its role in the ambit of Article 21. So I really feel privileged and as well as blessed in the presence of my guru, Professor Preeti Saxena, ma'am, and I also would like to grateful to Professor Preeti Mishra, ma'am, who invite me to share my view and provide this opportunity.
Thank you so much.
I will try to input with regard to my knowledge of liberty, personal liberty, and its role in the expansion of Article 21. So, as I am a student and remain students of Professor Preeti Saxena, ma'am, so I was little bit nervous, but I hope that she will give me courage and bless me. Thank you, ma'am. So, my finding with regard to terms liberty and personal liberty is that the preamble is the burden, and the terms of liberty which is used in the preamble, liberty of expressions, liberty of belief, liberty of faith, and perceptions. So, these terms is liberty have very significance. Being a part of preamble of the Indian constitutions. And as a student law, we all know that liberty of thought and liberty of expression become an integral part of Article 19, Clause 1, Subclause A as a fundamental right. Similarly, a liberty of belief and liberty of faith and worship is another fundamental right which is a part of freedom of religion under Article 25 and 26. So these have the terms liberty own significance and being a part of preamble as well as the fundamental rights. Their interpretation may be limited, that they are restricted only about thought and expressions, belief and worships. But the meaning and the dimension of the personal liberty is much wider. When I go and search about the personal liberty and the meaning of the personal liberty, then I find in the Oxford Dictionary, the meaning of personal liberty as per Oxford Dictionary, the freedom of an individual to do as the please, limited by the authority of politically organized society to regulate his actions to secure the public health, safety, morals, or of the other recognized interest. So this personal liberty have a very wide meanings with regard to human being, with regard to person. Now I come to the meaning of the personal liberty under Article 21. Under Article 21, we all know the Article 21, the bare Act said no person shall be deprived from his life and personal liberty except according to procedure established by law. Article 21 is being a fundamental right, and using the word by our constitution makers, person, it means this right is available to the citizen of India as well as the foreigners. So this right is available to all the human beings across the globes if they are present within the territory of India. So that's a significance of the person used in these articles. The another words which is very important and significant to be discussed over here, the no person shall be deprived from his life and personal liberty. I'm not discussing personal right to life here because I'm restricted only up to the personal liberty, the another part of this articles. So before I move ahead, I also compare the terms, that is the last phrase of this article, that is procedure established by law, and the procedure and the American, US due process of law. We all know that in original American US Constitution, there was no fundamental right. Later on, it was added as a Bill of Right. So the Fifth Amendment of the Constitution of US, America guarantees the fundamental right of life and liberty, which was read like that: no person shall be deprived of his life, liberty, or property without due process of law. So here the terms property is also add-on as compared to the Indian constitutions. And the another term is the due process of law. Our constitution maker, specifically chairman of B.R. Ambedkar, have a choice that they can add the word due process of law in place of procedure established by law. And there are several members during the Constitutional Assembly were in favor to add the word due process of law, but Dr. Ambedkar was not agree, and he said that the due process of law was explained as by Ambedkar. The due process clause in my judgment would give the judiciary the power to question the law made by the legislature on the ground whether that law is in keeping with the certain fundamental principles relating to rights of the individuals. In other words, we can say the judiciary would be endowed with the authority to question the law not merely on the ground of whether it was in access to of authority of the legislature, but also on the ground whether the law is good law, apart from the question of the power of the legislature making the law. So certainly the reasoning given by the B.R. Ambedkar was not in favor of due process of law, because it gives the extraordinary power to the judiciary and make the questions over the legislature to make the laws. So therefore, they restrict or they limit the judiciary by adding the word procedure established by law. And we all know the procedure also be made by the legislatures, not by the judiciary or any executive authorities. Now, then what the role of the judiciary? The role of the judiciary to watchdog whether the administrative authorities, executive authorities follow the procedure established by law or not. For that, we all know, and I am sure that we all read about the A.K. Gopalan case. But before A.K. Gopalan case, I just want to say something more with regard to personal liberties. The personal liberty have, as I stated in the earlier, that it have a very wide meanings. In one of the important case, the Supreme Court pointed out the personal liberty doesn't mean only liberty the persons, but it means the liberty or right attached to the person, that is just persona. The court said about the right attached to the person, just persona. And being a free person, being a liberate person, we have to enjoy our right as we can do within the restrictions or within the definition of the personal liberty, as I have stated in my beginning arguments with regard to personal liberty of Oxford meanings. Further, the judge said the personal liberty which is used in Article 21 as a compendious terms. Compendium terms mean it is the foundation of rights, fountain of rights. So many rights are emerges from the personal liberty. It means it contains variety of rights which go to make up the personal liberty of the man. We can't enjoy our life up to the fullest extent without having a personal liberty as a fundamental right. The Mukherjee just said in his own word about the personal liberty. He said, In ordinary language, personal liberty means the liberty relating to or concerning the person or body of the individual, and personal liberty in this sense is the antithesis of the physical restraint or coercions. So this is the statement of the Mukherjee itself reveal about the importance of the personal liberty in our life. It is an antithesis of the physical restraint. If the government or executive authority hinder the personal liberty right, then certainly we can't say that we enjoy our rights. The famous Dicey also have thoughts about the personal liberty. He said, personal liberty means a personal right not to be subjected to imprisonment, arrest, or other physical coercion in any manner that does not admit legal justifications. Means here again, he quoted somehow related to the Article 21 of the Indian Constitution that if authorities subject to imprisonment or arrest, then they should have to have a legal justifications. Without legal justifications, no person can be detained, no person can be imprisonment, no person can be arrested. So here the focus of the Dicey is the legal justifications with regard to infringement of the personal liberty. He further said that it is a negative right of not being subjected to any form of physical restraint or coercion that constitute the essence of personal liberty and not mere freedom to move to any part of the Indian territories. So this is also the Article 21 started with no person. So it is obviously it's a negative rights. But the thing is that it is very, very important rights. And as I said earlier, that it is the fountain of the rights. In the Kharak Singh case, again, the Supreme Court get the opportunity to define the personal liberty. In this case, Kharak Singh, the personal liberty is widen the dimension and by saying that the minority judgment of the Subba Rao, who gave actually very wide interpretation of the personal liberty by saying that it would embrace almost every facet of personal liberty recognized in US under the due process clause. So here the Justice Subba Rao stretch the meaning of the terms procedure established by law and equalize to the due process of law. However, he was in minority judgment, so it not become a law under Article 141. But certainly, sometimes the minority judgment is very, very important, which may be a majority decision in coming days. It happened. The Justice Fazal Ali dissenting opinion in A.K. Gopalan case become the majority in Menga Gandhi versus Union of India. So here the Justice Subba Rao equalize or just make a comparison between the due process of law of America as well as procedure established by law. And by this way, there is a new trend established between, or there is a bridge established between the Article 21 and 19. In the Article 21 and 19 have a relation, very strong relations. Because the fundamental right of life and personal liberty and the freedom of speech and expression, freedom of movement, freedom to assembly without arms, they have a connections. And they also relate the Article 10 of the UDHR. So the interrelation between the Article 21 and 19, which was established by the Justice Subba Rao in Kharak Singh, as a majority decision in the Rustam Kawasi's Kopar versus Union of India. This is again a very important judgment In Rustam case, the minority decision of the Subbarao become the majority. And the later on, in Menka Gandhi versus India, the minority judgment of the Justice Fazal Ali become the majority judgment, where the Justice Bhagwati observed the expression personal liberty in Article 21 is of the widest amplitude, and it covers a variety of rights which go to constitute the personal liberty of man, and some of them have been raised to the status of distinct fundamental right and giving the additional protection under Article 19. The right to go abroad is a part of the personal liberty. So here, he developed a new right which was initiated or discussed in Satnam Singh case. Later on, it became a right in Menka Gandhi versus of India through Justice Bhagwati. Here, the majority decisions are also be known by the triology. The procedure established by law must be just and fair and reasonable. So it is again a question of research for all our students, all our law students. Why the judges were used triology? Just procedure established by law should be just, should be fair, should be reasonable. Why not the one term is sufficient that the procedure established by law should be just? There is no need to be fairness or reasonableness. No, they categorically use these three terms and they have their own meanings. That the procedure established by law should be just, fair, and reasonable. And this is actually the import of the due process of law via a backdoor in the Indian legal system. So these terms are actually cover all the amplitude of the due process of law, which is directly cannot be a part of Indian Constitution, but indirectly it become a part of the Indian Constitution through the Menka Gandhi case. So this is a very important thing, and I just suggest to the students who are listening me that you just analyze why there is a need of the Supreme Court to use these three terms all together to explain the procedure established by law. Here again, the Justice Kasnaiya judgment or statement is also very, very important in Menka Gandhi case, in which Justice Iyer said, and he quoted the Socrates, the view of the Socrates with regard to the personal liberty. Socrates, who was quoted by the Justice Kasnaiya in Menka Gandhi case, he said, the Socrates let down the citizen has a right to go where he pleases and he take his goods with him. And this right was also recognized in Magna Carta as well. Means Socrates was of the view that every citizen has a right to go where he pleases. I mean, there is no boundary for the man. But here the Socrates used the term citizen. It means it is restricted only up to the particular state, particular nations. But I'm the view of that any person who have the passport can be go any place where he pleases, where she pleases. And he also carry his belongingness, no doubt about that. So only the restriction of the passport and having a proper visa, then you can go any places. There was no restrictions. So this is the widest amplitude and the explanations of the personal liberty through Justice Kasnaiya, which quoted the Socrates in Menka Gandhi case. Again, another judge of the same case, Chief Justice Wake, gave a very wide explanation of personal liberty in the following sentence, which I'm reading for you because I could not able to share the PPTs. Justice Wake said, I think that both right of personal security and personal liberty recognized by the Blackstone terms natural law are embodied in Article 21 of the Constitution. So here he added one more term, that is personal security. So along with the personal liberty, personal security should be recognized as a part of the natural law and which is embodied in Article 21 of the Constitution. So the confirmation of the Chief Justice Wake with regard to personal security and personal liberty as a part of natural law, and natural law is also embodied in Article 21, is enough to say or to open the vistas for the adding the rights in Article 21. We all know when there was a debate during the Constitutional Assembly with regard to the segregation between the Part 3rd and Part 4th of the Indian Constitutions. Why the Part 4th become non-justiciable? Why the Part 3rd is justiciable? On this debate, the final arguments of the Dr. B.R. Ambedkar, I remembered, and I want to share with all of you. He said that the amendment procedure of the Indian Constitution is so moderate that our progeny may convert the non-justiciable act, that is Part 4, into the Part 3rd as and when they required, as and when they need it. And it become true. We all know that there are so many non-justiciable rights become a justiciable right and being a part of Article 20. No doubt about Article 21A, now it become a right to education. It become a fundamental right under Article 21A through the 86 Constitutional Amendment. Before 86 Constitutional Amendment, it was merely a right to education under Article 45 as a right to education. However, before the 86 Amendment in Moini Jain versus State of Karnataka, it became a right. It was acknowledged by the Supreme Court, right to education as a fundamental right. Similarly, right to speedy justice. Similarly, right to equal pay for equal work. And there are so many series of rights which directly or indirectly take an inference from the article, from the Part 4th of Indian Constitution and become a part of Article 21 as an inferred right. So by this way, we can say that the words of the Dr. B.R. Ambedkar becomes true. And this is the reason, this is the definitions or the explanation of various judges in various judgment that it become possible to stress the dimension of Article 21, and so many rights become an inferred right under Article 21. Here I also want to share a relevant, the views of the Blackstones about the personal liberty and personal security. As I stated, Justice Beg actually quoted the Blackstone's theory of personal liberty and personal security. What actually the views of Blackstone with regard to these two terms, personal liberty and personal security? He said, the personal liberty consists in the power of locomotion, of changing the situation, or moving one person to whatever places one owns inclination, may direct without imprisonment or restraint, unless by the due process of law. So this is the definition of the personal liberty in the words of Blackstones. So again, he focused that the person can move as per his or her choice across the territory of the country. There shall not be an imprisonment, there shall not be an restraint. If it is, then it should be according to due process of law. He further explained the term the personal security. As per personal security is concerned, he said, the personal security consists in personal legal and uninterpreted enjoyment of his life and his limbs, his body, his health, and his reputation. So as far as personal security is concerned, he just limited the enjoyment of his body parts. Means under the head of personal security, a person have a legal or uninterrupted enjoyment of his life, his limbs, his body, his health, and his reputation. So far as reputation is concerned, it is intangible rights, and other rights are tangible rights. They may be enjoy as per the case. But this is very, very relevant and important to stretching the dimension of the Article 21, because the Blackstone was cited by the Justice Beg in his judgment. Now, the another dimension which I want to share over here, as I have read for you, that the property is a part of personal liberty in America, in USA. I again read for your refresh the memory. No person shall be deprived of his life, liberty, or property without the due process of law. Now, in Indian Constitution, whether right to personal liberty include the right to property or not? I think question is affirmative. Yes, the right to property is also be a part of personal liberty within the Article 21 of the Indian Constitution. Here I just read an article of Justice Matthew on the personal liberty, and he mentioned his own article. Justice Matthew mentioned that in a society with a mixed economy, who can be sure that a freedom in relation to property might not be regarded as an aspect of individual freedom? People without property have a tendency to become a slave. This is very important, points mentioned by Justice Matthew. That the people without property have a tendency to become a slave. It's true. If you see around you, then you find that those people who have no property, who are landless, they have slavery tendency in their attitude. I also belongs to Blaze. I have an experience in my Blaze that those people who do not have any property, so they are doing on the labor, daily wages labor. During the pandemic periods, during the corona, their situation were very, very worst. Because they do not have a property, and due to the lockdown across the country, the people have no employment. उनकी सिचुएशन बहुत बदतर हो गई थी और स्थिति ये थी कि उनसे आप गांव में कोई भी काम करा लीजिए, बस उनको खाना दे दीजिए, उनके परिवार के लिए खाना दे दीजिए, कुछ अनाज दे दीजिए. So Justice Matthew's statement in his articles is true. It becomes true. It is only up to us that we will find out such type of a example around us. So this is the things. It would be a part of personal liberty or not. Yes, the personal right to property is a right, a personal liberty within the Article 21. And we all know the slaves and the theory about the slaves. The slaves become the property of others. He mentioned in his own article that they will come to say, make us slaves, but feed us. So those who do not have a property, they have a tendency to make us slaves and feed us. So therefore, under the personal liberty, if we want to give a personal liberty to our own citizens, then we also give them a right to property. Liberty, independence, self-respect, all these things have the roots in the properties. No liberty, no independence, no self-respect can be maintained without having a property. So to de-integrate the institution of property is to shut one eyes to stark reality evidenced by the innate instinct and steady object of pursuit of the vast majority of the peoples. Protection of the property interests may quite fairly be deemed inappropriate circumstances in aspect of the freedoms. So not only having the property, but the protection of the property must be maintained. And we should encourage to our own citizens to gather the properties. Of course, this is a common tendency. Everyone wants to be property. Here just I want to quote the great management philosopher, Abraham Maslow. He gave the need hierarchy theory. And those who are also have an interest in the management subject or a public administration, then they obviously read the Abraham Maslow need hierarchy theory. In need hierarchy theory, he said the first need for the human being is hunger, thirst, sex. These are the basics need. And when the peoples will able to attain the first need, then they thought about this second need. As per Abraham Maslow, the second need is need of security. They want to secure by collecting the properties, by making money. So therefore, the pupils, when they are able to get the first need, fulfill the first need, then they thought about the second need, that is the security need, in which they want to gather the properties. So therefore, it would be possible to argue that right to property is already covered by the right to personal liberty. This is one of the reasons, I think, why the 44th Constitutional Amendment, the right to property shifted from fundamental right to legal right. Because the personal liberty is covered the right to property as well. There may be another reason also, but this is also be a reason that the right to property shifted from fundamental right to legal rights. Similarly, when we're moving forward, then I want to quote the another important case law in this personal with regard to personal liberty, that is Mopil Nayyar case. In this case, the Supreme Court also accept the similar contention, and they use the term law occurring in Article 31, Clause 1 and Article 205, that law, which is a law in Article 31, Clause 1 and Article 205, it should pass the test of Article 265, and which can also be passed through Article 14, 19, Clause 1A, Subclause F, and Article 30. Means if any law made by the Parliament, it should be passed through a test of Article 14, 19, Clause 1, Subclause F, and 31. Then only it can be a good law. Now next, the another important case with regard to personal liberty, in which the personal liberty was discussed in detail, that is K.S. Putta Swami versus Union of India in August 2017. In this case, the Supreme Court recognized right to privacy as a fundamental right, we all know. And in his concurring opinion, Justice Bobde noted that privacy was vital to a personal liberty, which include the privacy of body or mind. So the privacy was inarticulate major premise in Part 3rd of the Indian Constitution. That is the Justice Bobde concurring opinion with regard to personal liberty. He considered the right to privacy was an integral part of the personal liberty. So personal liberty also include privacy of body or mind. So this is the new dimension which was given by the Justice Bobde with regard to personal liberty and added privacy of body or mind as a part of personal liberty through this judgment. And this is the Justice Bobde assertions paved the way a nuanced application of right to personal liberty and life in the Navtej Johar case, that is decriminalized homosexualities. So decriminalization of the homosexuality, which was declared by the Supreme Court in Navtej Johar case, is actually the beginning through Justice Bobde judgment in Uttar Swami case. In the morning, I was discussed with my friend about the new dimension of the personal liberties. The dimension of the personal liberties is still stretching day by day. And it incorporated so many other rights, future rights, fourth generation rights. And when I'm talking about the fourth generation right, then it may be a right of genomes, right to utilize the artificial intelligence here as a right or for the betterment of the society. I first time heard the terms Machino sapiens through my guru, Proti Saxena. And I thought that how can a ma'am can think like that the Machino sapiens may be a robot, a name of robot. So this is really, ma'am, every time give me some new information, some new terms on which I think, rethink, and try to assimilate in myself. So the right, four generations rights may include under the dimension of the personal liberty. It may happen true in coming days or coming decades, but certainly we are moving. And we all know the law is a dynamic subject, so it always we go on and on. As I restricted only in this lecture about the role of personal liberty, so the next important judgment, which is also be a very news during the 2020 during the COVID period, Arnab Goswami case. Arnab Goswami versus State of Maharashtra. We all know about the Arnab Goswami. He's a leading journalist. And we all know his inclination towards which party or which government. Unfortunately or fortunately, in Bombay, the government was a different party. Earlier, he was very comfortable. But during this current government in Maharashtra, he was a little bit uncomfortable and he was arrested in an earlier case. And he was filed a writ petition against his arresting. And he filed a writ in the Bombay High Court invoking the jurisdiction of the High Court of the Judicature of Bombay under Article 226 and 227 of the Indian Constitution, and also the Section 482 of the Code of CRPC. The appellant sought three substantive reliefs from the Bombay High Court. The first one, a habeas corpus writ alleging that he was illegally apprehended and wrongfully detained by the station house officers at Alibag police station in the district of Raigad in Maharashtra in relation to FIR registered by 5 May 2018 in relation to section 306 and 34 of the IPC, in spite of an early intermination report accepted by the magistrate. second remedy sought to by Arnab Goswami through this writ petition, the dissolution of the aforementioned FIR, and third remedy, the arrest memo on the basis on which the appellant was arrested to be quashed. So these are the three remedies claimed by the Arnab Goswami in his case and to approach the High Court. However, the High Court declined or refused to grant the bail, citing the judgment of the Supreme Court in the case of State of Telangana versus Habib 2017. In this case, the Supreme Court mentioned and High Court cited that the petition of interim relief was based on the premise that the appellant had been unlawfully detained and that because he was in judicial custody, it would not entertain the request for bail or a stay of the investigation in the exercise of extraordinary jurisdictions of the court. The High Court rejected the appellant's preliminary contention that the accusation in the FIR as written to do not disclose the commission of a crime under Section 306 of IPC. High Court also stated that the power to quash should be used sparingly and only in the rare and suitable situation, which was not in the case of Arnab Goswami. It could also be used in severe circumstances, also to prevent the misuse of legal process. So therefore, the High Court has denied the appellant interim's bail. As we all know, and we all be knowing this is because a leading case, he approached to Supreme Court. And Supreme Court have a different opinion than the High Court of the Bombay. Supreme Court said that the High Court neglected to examine a key issue that should have been considered while dealing the questioning of petition under Article 226 of the Indian Constitution or Section 482 of the CRPC. However, High Court in this ruling dated 9 November 2020 permitted the petition for questioning to be continued for hearing a month later. This is the objectionable part, as stated by the Supreme Court in its own judgment, that why the High Court will hear this case after a month? Why not right now? So therefore denied the appellant request for interim bail and consigned him to remedies under Section 439 of CRPC in meanwhile the personal liberty of the appellant had been sacrificed. So I cited this case in my lecture just because of the terms personal liberty uses by the Supreme Court with regard to sacrifice the personal liberty of the Arnab Goswami. And he further said, court further said, to determine whether the acquisition of the FIR as they stand place the matter within the purview of Section 306, read with Section 34 of the IPC. Therefore, the Supreme Court was now called upon to do so. So this part is also be neglected by the High Court to deliver the judgment and to deny the bail to the Arnab Goswami in this case. Supreme Court further said, the suicide note indicate the deceased's state of suffering and cannot be interpreted as reflecting anything deliberate on the part of the accused that the deceased would committed suicide. I think you remembering the fact of this case, actually the deceased was, the anterior decorators, and Arnab Goswami hired him to decorate his own studio. But the bill of the, decorations done by the deceased was not paid in fully. And by repeating requesting of the deceased to the Arnab denied and used his power. And due to the, the loan liabilities and other things, the deceased committed the suicide by leaving a suicide note, in which he categorically mentioned that for committing suicide, the Arnab Goswami is liable. But initially, from 2018 to 2020, there was no action against the FIR done by the deceased. But as the government changed, then the actions taken against Arnab Goswami when Arnab Goswami deliberately, make some statement against the Maharashtra government led by Uddhav Thackeray. So it happened on the, the political motivated actions. So therefore, the court said that the required procedures, it would have been clear that the element of the offense had not been proved prima facie. As a result of its inability to carry out its role under Section 482, the High Court has barred itself from the exercising its authority under Article 226 to entertain the appellant bail applications. So here, I'm just quoting these statements that here the Supreme Court is actually one by one making the, incompetency or insufficiency of the, or in dealing to the, High Court judges with regard to the bail of the appellant. But here I'm just citing this case with regard to personal liberty, as I told you. So when evaluating such an application in the Article 226, the High Court must exercise its authority with caution based on the fact of such case. However, the High Court should not abstain from using its authority where a citizen has been unlawfully deprived of their personal liberty due to the excess of state powers. So as I mentioned earlier, that this was a politically motivated arresting to Arnab Goswami due to some or other reasons. So here the court is categorically mentioned the personal liberty due to the access of state powers. Now this is again a question that how we can say that the state used excessive power. I think earlier when the court or when the authority have not taken an action against the FIR lodge in police station, that is the inability or incompetency of that police station in charge. Later on the political pressures, he taken a decision. I think this action should be taken in 2000 as and when the FIR was filed. But at that time, there was no actions. So therefore, the petition under Section 482 was granted and the FIR was quashed, overturning the High Court decision. Taking these parameters into an account, the order dated 11 November 2020 called for the appellant release on bail. So this is finally Arnab Goswami was able to get the bail through the Supreme Court. But here I just want to share the views of the Supreme Court on the personal liberty, which is a topic of today. The Apex Court held that the human liberty is an valuable constitutional asset that is unquestionably susceptible to the restriction by the lawfully passed laws. He further said that as a result, the citizen is subject to order of criminal laws and process. Section 482 further acknowledged the High Court inherent jurisdictions to issue such order as are required to give effect to provision of CRPC and prohibit abuse of any of the court process or otherwise secure the end of the justice. According to Supreme Court, the High Court must be seen as an assistant to the preservation of the fundamental values of the liberty. Moreover, the fabric of the Constitution is woven with the right of liberty. So these are the new dimension given by the Supreme Court in this Arnab Goswami with regard to personal liberty and human liberty. So therefore, the requirement to ensure the impartial investigation of crime is undeniably essential in itself because it protects at one level the victim rights at the more basic level, the interest of the society in ensuring the crime is investigated and dealt with in accordance with the applicable law. Or on the other hand, we can say that the criminal law is something that the High Court and subordinate court in this nation must be aware of it. So here, I think the Supreme Court refresh or give the directions to the High Court and the Supreme Court that they should be follow or stop the abuse of the criminal law. Because we all know if you go through across the country, then you find out the misuse of the criminal laws. We all know that the previous government, how they misuse the criminal law against their contenders. If one party is in power, then the party which were earlier in power, the leader of that party can be sent to jail by using the criminal laws. There are so many examples also in our own state, that is in UP. I'm not quoting over here, but we are just being a student of law, how the criminal law is misused by the government in ruling. We all know the case of Chidambaram, how many days Mr. Chidambaram remain in jail just because of the another party is in central power. So I think that judiciary highlighted the misuse of the criminal law and warned to the High Court and lower courts that you should stop the misuse of the criminal law through this judgment. A further court said that according to Supreme Court, the court must be mindful of the need to protect the public's interest by ensuring that the proper implementation of criminal law is not be hampered. Now the question is that the arresting of the Goswami in 2020 is proper implementation of the criminal law, or he was not arrested between the 2018 to 2020 is a question of proper implementation of criminal law. So this is the questions. In the morning, I was in discussion with my friend, and we were discussing about the rule of law. I think this is the preservation of the rule of law, or this is the rule of law of in place of rule of law, it is rule of party who is in power. Certainly, the rule of law is not implemented in toto. So in place of rule of law, rule of party in power is more seems to be implemented. So the fair investigation of the crime is an add to the same. It is also the responsibility of the court at all level, the district court, high court, and the Supreme Court, to guarantee that the criminal law does not become a tool for the selective harassment of the people. This is very important, the sentence, the selective harassment of people. If the Supreme Court acknowledge the selective harassment of the people, then why not they give some directions to the concerned authority why they select a particular person for the harassment? Why they are not able to adhere the rule of law rather than to selective harassment? So that is the point of question that we have to be thought, and we should write an article on it. So court should be aware of both the side of the spectrum. It is further said by the court. The need to guarantee appropriate criminal law enforcement to the one hand, and the need to ensure that the law does not become a pretext for targeted harassment to the others. I don't think that the harassment of the Arnab Goswami was take place by the Maharashtra police. However, they were negligent that they were not arrested from 2018 to 2020. He was arrested in 2018. Then I think such situation, such case will not be a discussion. We will be a part of discussion over here. So this is the, carelessness, negligence of the police stations in charge of that particular district. But certainly the harassment is a part of Indian legal system right now in various ways. Liberty across human generation is in a tenuous as can be liberty thrives via the vigilance of our citizens, the clamor of the media and the dusty hallways of the code dedicated to the rules by laws. Yet, far too frequently, liberties suffer as a result of one of these components failing. The court thus noted that as judge they would do well to remember that it is through the use of bail that the criminal justice system primarily purpose in upholding the presumption of innocence as expressed more eloquently. So the bail remedy is a solemn manifestation of the judicial system humanity. It is sincere hope that Indian courts will be actually aware of the need to broaden the footprint of the liberty and will utilize the present judgment methodology as a decision-making yardstick in future bail cases. So this is the interpretation of the terms personal liberty by the judges, by the honorable judges in Arnab Goswami case, in which they are saying to need to broaden the footprint of the liberty, that is personal liberty, and it is needed. I'm also have the same mindset that the personal liberty is further broadened, and it is broadened day by day and includes all other generations, right? Maybe fourth generation, fifth generation, sixth generation, as the case may be. And it stretches its dimension of Article 21. So with this, I just conclude myself. I like if any questions with regard to personal liberty and Article 21. Thank you. Now over to Jaya to carry forward this session.
Thank you, sir, for a very enlightening and informative lecture. And I think that after listening you, the student particularly is having some question in their mind. So if anybody of you want to ask something, want to put your query before sir, so please.
I just wish to congratulate you, Yadav. This was a wonderful correlation.
Thank you.
Of liberty with property and other rights also, and a comparison of the US Supreme Court with that of the Indian provision. Good.
Thank you, ma'am. Thank you. Thank you. Feel blessed.
Okay, Yadavji, I have two wonderful congratulations to you for such a erudite and presenting your thoughts in such a nice way. I am sure that the students must have got a lot. It must have ignited their mind.
Thank you.
So any student, if anybody wants to ask something,
ma'am,
wants to put their observation or comment regarding the topic. Yes, Shalja wants to say something. Yes, Shalja.
Yes. Good afternoon, ma'am. Good afternoon, sir. Sir, I have one question regarding your opinion on a point, and another thing. That first thing that
can you please switch on your camera, Shalja?
Okay, definitely, ma'am. Please wait, ma'am, for 2 minutes. My first question is that the trilogy that you talked about, that is just, reasonable, and just, fair, and reasonable. In your opinion, is there another word that could aid in implementation, a better implementation of Article 21, if there is? And the second thing that I would like to ask is that the whole case of Justice Karnan, where an apprehension was against him, and he was about to get arrested, and then he went on some kind of an exile for 2 months till the retirement, and then the whole proceeding was shut down. So, in your opinion, who is more at fault? That is judiciary for playing into the political propaganda, or is it the bureaucracy? Because so we talk about separation of power, but it is in theory because all these organs work together. Either they fight or they work in harmony, but they are together and they have to work together. So, in your opinion, who is more at fault?
Thank you. Thank you very much, Shalja, for asking a very good question. So far as your first part of question is concerned, with regard to the terms trilogy used by just, fair and reasonable, I think it's my personal opinion that the court and in Maneka Gandhi categorically use these terms because these three terms, complete the whole strictures of due process of law indirect way. And if they are using one terms, either just and fairness or reasonable, either of, then it may not be a complete, import of the due process in law in India. So I think these three terms have not left no rooms for further adding new terms. So I don't think I have an words to add fourth one in these three. These are sufficient and suffice to explain the, the procedure established by law should be just and fair and reasonable. And I feel humble that I am unable to add any fourth terms. And so far as your Justice Karnan judgment or their case is concerned, obviously I thought that there was an injustice take place with him. And I have, great sympathy with him. Just raising the voice against the top judicial persons, he was penalized in this way. This is my personal opinion again. And yes, of course, there is always be a nepotism in the selection of the higher judiciary, and that's why they are keeping, or they are willing to continue the collegium systems. They are not, agree with the National Judicial Commission led by the earlier NDA government. But it should be, I personally feel, and this is not a right forum, but I'm a little bit there, and my guru is here to protect me. So I can tell you that in judiciary also, there are 200 families across the India. From their family members become the part of higher judiciary. Similarly, I also have the same opinion. Across the India, there are 500 families from their family members become the member of parliament or member of legislative assembly. And recently, I have heard about the one of the TV debate in which one of the politicians was say that there is no democracy because 90% legislator, that is MLA and MPs, come from the political backgrounds. Only the 10% pupils are coming from non-political backgrounds, and they make their entry in Indian political system. So if the 90% people are coming from the political party, and if the 60 or 70% or more than that also be part of the judicial from the judicial families, then certainly such things cannot be sustained, and there was little rooms to enter a new individuals into judiciary and in political system. So this is my personal opinion, and I think the things must be changed. But for that, we are moving towards new regulations. Maybe if you see that any government, any form of government cannot be sustained more than 70 or 80. In 1857 to 1947, approximately 80 years, right? The government is by the Queen Elizabeth, right? From next, if you go to the East India Company rule, then they also be ruled for 90 years, right? And after 1947 to till date, almost 70 years over. So next 20 years, the democracy will be work in India. And again, that the revolution will take place and new form governments will come. Any government, any form of, whether it is in a democracy or non-democracy, or it can be sustained only maximum up to 90 years. तो उस 90 साल में 70 साल हो चुके हैं, तो अभी 20 ही साल बचे हैं. और इस 20 सालों में मुझे ऐसा लगता है कि प्रजातंत्र अपने लोएस्ट और न्यूनतम लेवल पे पहुंच जाएगा, और उसके बाद रेवोल्यूशन होगा और कोई नया फॉर्म का आएगा. जिस तरह से 1857 के बाद जो विद्रोह हुआ, उसके बाद जो है वो रूल चेंज हुआ ईस्ट इंडिया कंपनी से ब्रिटिश गवर्नमेंट को गया और वो फिर 1947 तक रन किया, ऑलमोस्ट 90 साल। तो इसी तरह से 90 साल पूरे होने वाले हैं। तो इसके बाद कुछ ना कुछ होगा, फिर पूरी जुडिशरी रीस्ट्रक्चर होगी, पूरा डेमोक्रेटिक रीस्ट्रक्चर होगा। क्या होगा, कैसे होगा, ये अभी मैं नहीं कह सकता। हम होंगे भी, नहीं भी होंगे, इसका भी कोई गारंटी नहीं, बट ये होगा। ये जो प्रेजेंट फॉर्म ऑफ गवर्नमेंट है, इसकी लाइफ नेक्स्ट 20 इयर्स ये और बची।
So thank you, sir. आपने बहुत अच्छा observation बताया.
So,
Thank you very
one
much.
thing, Shailja, which can be included, that is equitable also.
Yes,
Just
ma'am.
fair, reasonable with equitable. That was the decision
Yes.
in Maneka Gandhi. Okay.
Yes,
Thank you, ma'am.
Anyone else want to ask any question? Want to ask something? I think no doubts are left. So thank you, sir. I must say, sir is a proud alumnus of Department of Human Rights, who is headed many.
Thank you, Rashida ma'am. Thank you very much.
Okay, sir. And presently aiding as director of Amity Law University, Lucknow. So sir is busy, but I thank you, sir, for giving your time, your vital time from your busy schedule, and making such a good correlation of liberty and right to life of the Constitution, where you covered, I think, the ancient Greek political legal thought, and then psychology also, and definitely the many leading and recent cases. So thank you very much, sir, for your very enlightening lecture. Further, I also thank the Head Department of Human Rights, Professor Preeti Mishra ma'am, who is also the Dean of School of Legal Studies, for organizing, I must say, this lecture series. So we all getting a chance to listen to different views on different topics. We are definitely, which is adding in a treasure of knowledge. And I also mention my sincere thanks to Professor Saxena ma'am, who is presently the Director of CPGLS and a Senior Professor of Department of Human Rights, who is always stand as a source of inspiration for organizing these all such academic activities. And lastly, I would like to place my hearty thanks to all the participants who are present here and who have given their precious time. So thank you very much. Thanks.
Just a second, Rashida, just a second. I would like to add that Nivedita is here from the mass communication to cover this event. So I thank you, Nivedita, for being here for the session.
Thank you.
Okay. Thank you so much for joining again. Thank you so much.
Thank you, Nivedita.
I thank all the participants, Rashida for conducting the session, and Jaya for introduction. My senior faculty member, Professor Pradesh Saxena, for joining and encouraging us on all the occasions. I once again thank J.P. Yadav ji for giving us this opportunity to introduce you to our students so that they will get benefit from your vast experience in this field of constitutional law. Thank you all. Thank you so much.
Thank you, ma'am. Thank you. Thank you to all.
Thank you.
Thank you, ma'am. Thank you, sir.